Good day, ladies and gentlemen. This is Dr. Frel, your professor. Hello class, good morning. Our topic for this morning is on the crimes against personal liberty and security. These crimes are those committed principally by private persons. If a public officer participates, then the crime must come from a private person as the principal accused. Otherwise, the crime would be a crime against the fundamental laws of the state. So we will have kidnapping first. So for kidnapping, this is for the charge. Again, class 4, the charge of kidnapping to prosper the deprivation of the victim's liberty, which is essential element of the offense, must be proved. So this crime may be committed by transporting the victim from one place to another place or by merely detaining him, because detention is also kidnapping. So for detention to be considered illegal, then these are the elements. First, the detention lasted for more than 3 days. Second, the offenders simulated public authority. Third, physical injuries were inflicted on the victim. Then next, there is the threats to kill him which is being made. And last, the victim is a female, public officer, or a minor, except when the accused is any of the parents. Now, what are the qualifying circumstances of kidnapping? First is, of course, ransom is demanded. When we say ransom, that is the consideration paid or demanded for the release of someone or of course of something from captivity. Then second is that the victim is killed or dies as a consequence of kidnapping. Then number 3, the victim is raped. That is another qualifying circumstance. And another one is that the victim is subjected to torture or dehumanizing acts. Now, what is ransom? It is the payment that releases a victim from captivity. It can hardly be assumed that when complainant readily gave the cash demanded of her at gunpoint, what she gave under the circumstances was in the concept of a ransom. The definition was taken from People of the Philippines versus Puno. Now, even if what was demanded was a compensation to the offender or for expenses of the board and the hotel lodging of the victim, or the amount owed by the victim to her creditor, it is still ransom because it is the condition for the release of the victim. That was from People of the Philippines versus Tomio. Then next is coercion. This is the use of express or implied threats of violence or reprisal, such as or other intimidating behavior that puts a person in immediate fear of the consequences in order to compel the person to act against his or her will. So, absent such determined intent and duration of restraint, the mere curtailment of freedom of movement would most constitute coercion and not kidnapping. Thus, taken from People of the Philippines versus Marahas. Because when we say kidnapping, it is the unlawful transportation, asportation in confinement of a person against their will. Now, class, it was ruled now that where the person kidnapped is killed in the course of the detention, regardless of whether the killing was purposely sought or was merely an aftermath, the kidnapping and murder or homicide can no longer be complex under Article 48, nor be treated as separate crimes, but it will be punished as a special complex crime. This, according to People of the Philippines versus Timorin. Now, class, here are some important points to remember. One is, it is rape only if the original intent is rape, even if the victim was taken away. B. Kidnapping with rape if the original intent is to kidnap and the rape was merely an afterthought or only a composite of the crime. Third, forcible abduction with rape if the taking was with lewd design and rape was committed, and this can be considered as a complex crime. Then number 4, kidnapping and attempted rape if the rape was merely attempted, and forcible abduction only if the rape was merely attempted. Now, as regards to kidnapping with rape, the crime is considered composite if the woman kidnapped is also raped. When we say composite crime, this is one in which a substance is made up of more than one crime, but which is in the eyes of the law only a single indivisible offense is. This is also known as a special complex crime. Examples are robbery with homicide, robbery with rape, or rape with homicide. So, in this case of kidnapping with rape, at the outset, as if there is no lewd design. So, rape here is not a separate crime but merely a qualifying circumstance. So, even if there are multiple rapes, there is only one kidnapping with rape. So the others are not even aggravating for rape. That's not a circumstance in Article 14. So if rape was merely attempted, in here there are two separate crimes, kidnapping and attempted rape. Because in composite crimes, the component crimes must be in this stage specified by law. Now, another is forcible abduction with rape. So, the crime is complex since forcible abduction is a necessary means to commit the rape. At the outset, there is lewd design, and rape here is also a crime. If there are multiple rapes, only one rape shall be complex with abduction, while the other rapes will be treated as separate crimes. This according to People of the Philippines versus Jose. Now, if a rape is merely attempted, forcible abduction, this is forcible abduction only, because the attempted rape is a manifestation of lewd design. So, plus the elements of forcible abductions are one is that the person abducted is a woman, regardless of her age, civil status, or reputation, and two is that the abduction is against her will, and third is that the abduction is with lewd designs. Now let's have grave coercion elements. So a person is prevented by another from doing something not prohibited by law or compelled to do something against his will, be it right or wrong. So So, the prevention or compulsion is affected by violence, either by material force or such display of it as would produce intimidation and consequently control over the will of the party. And the person who restrains the will and liberty of another has no right to do so. Or, in other words, the restraint is not made under authority of a law or in the exercise of any lawful right. Then we have slight legal detention. In this case, the five circumstances in kidnapping must be absent. But even if the five circumstances are absent, the moment ransom is demanded, the crime is kidnapping. But unlike in kidnapping, voluntary release can mitigate the liability in serious illegal detention, provided that release is made within 3 days from the start of the detention. Another is before criminal prosecution can be commenced or has been commenced, or before the offender has accomplished his purpose. When we say mitigating class, as mentioned earlier, these are having the effect or of making something bad less severe, serious, or painful. So, mitigating circumstance are those that lessen the liability of the crime. Then another is arrest. This is the act of apprehending and taking a person into custody, and this is usually because the person has been suspected of or observed to have committed a crime. So, this is for delivering the person to the proper authorities, but was made without any reasonable ground, otherwise stated to be a warrantless arrest by the rules of court. So, this warrantless arrest can only be done if it is in the presence of the officer, or in the presence, the crime is being committed or actually committed or just attempting to commit the crime. And it has probable cause to believe based on personal knowledge of the crime or the person is escaped from prison. So, if the offender did not turn over the arrested to the judicial authority, then the crime will be kidnapping, because intent to turn over the victim to the judicial authorities is the essential element of the crime. So, in Article 269, it provides that if the offender feigns to arrest a person without any legal cause for the purpose of filing a charge against him. If a charge is filed, the detention is deemed an incident of the arrest and filing of the charges against him. It is the arrest that is penalized. Now, when do we have unlawful arrest? So this can be committed not only by private persons but also by public officers. This according to Morales versus Enrile, as long as the purpose of the arrest is to bring the victim to proper authority and to file a charge. So in Article 124, the public officer had no intention to bring the offended to proper authorities, but merely to detain the victim. So remember, class, that unlawful arrest is physically detaining someone without the legal right to do so. Or a false arrest must be perpetrated by one who asserts that he or she is acting pursuant to some legal authority, whereas a false imprisonment is any unlawful confinement of a person. Now we have the elements of kidnapping and failure to return a minor. First is if the offender has been entrusted with the custody of the minor. And 2, if he deliberately fails to restore said minor to his parents or guardian. And while kidnapping and serious illegal detention cannot be committed by the parents of the minor. So please be reminded, class, that this kidnapping and serious illegal detention cannot be committed by the parents of the minor. That's under Article 267, paragraph 4. Because in such a case, the crime is under 271. So the parent can only be liable if the child or victim is no longer a minor. Okay, now we have abandonment. So these are the 3 elements of the crime of abandonment. One is failure to render assistance to a person found in an uninhabited place. So if we fail to provide assistance to a person that we found in a place where there are no inhabitants, then we can be charged of abandonment. Second is abandonment of one's own victim in an accident. No? So these are usual incidents, no, in our community where those who abandon their victims in an accident can also be charged of abandonment. And third, failure to render assistance to child less than 7 years of age. So the offender is liable not only for the abandonment but also for all its consequences. Then another is trespass to dwelling. So for this to be committed, the place must be a dwelling, meaning that there is a dweller or an occupant on that place. So even if the place is meant for residence, like an apartment for rent, if at the time it is vacant, then the crime is trespass to property, not trespass to dwelling. It is the condition of the place that determines the crime committed, whether trespass to dwelling or trespass to property. Even if the structure is a garage, if it is used as a residence or a dwelling, the crime is still trespass to dwelling. So in here, class, against the will of the owner implies prohibition against entering. So this may be expressed or implied. This against the will of the owner. So if the offense is committed by means of violence or intimidation, the crime is now qualified trespass to dwelling. But when the entry is through an opening not intended for ingress or entrance, it is presumed that the entry is against the will of the dweller. Now, if the purpose of entry is to commit a more serious crime like rape or murder, and the trespasser has commenced overt acts directly related to the serious crime, trespass to dwelling becomes aggravating and is absorbed. When we say aggravating, class, this is making the problem or the offense worse or more serious. So in short, when it's a circumstance, then it adds to the gravity of the offense. So now, class, when no trespass is being committed, one is if the purpose of entry to dwelling is to prevent some serious harm to the person entering, the occupants or third persons. Second, if the purpose of entry is to render some aid or help to humanity or justice. And third, if the places entered are cafes, taverns, inns, and similar places while they are open. So it has to be noted that disco, restaurants, and the like may be the object of trespass, provided the place is closed for business at the time. But the crime is trespass to property and not trespass or not dwelling places, although it is included in Article 280. There are also cases where trespass may be involved but not committed. One is a violation of dwelling or domicile, where public officer is law enforcer but has no search warrant or with a spurious one, or he exceeds his authority in a service of a valid warrant. Or if there is unjust vexation or light coercion as to the entry to the dwelling or domicile. And third is in the state of necessity as provided in Article 280, paragraph 3, or other forms of theft under Article 308, paragraph 3, where the purpose of entry is to fish or to harvest or to gather cereals. No? So, the crime can be in the attempted, frustrated, or consummated stage of theft. And fifth, in cases of vagrancy, as in Article 202, number 4, as when the vacant property is not fenced and there is no prohibition to enter. So in this case class, it has to be noted that permission to enter may be given by household member with sufficient discretion. So when permission is given, there is no trespass. So trespass is not committed. And our anti-squatting law has been repealed. So if the entry to a private estate is for the purpose of building a dwelling and living therein, it is no longer punishable, but actor is subject to ejectment. When we say ejectment, this is the action or the process of evicting a tenant from the property. Now, class, there are 3 kinds of threat. We have the grave threats, light threats, and other light threats. When we say grave threats, the wrong threatened amounts to a crime which may or may not be accompanied by any condition. It is done by any person who shall threaten another with the infliction upon the person, honor, or property of the latter or of his family of any wrong amounting to a crime. So in here, benefit is not immediate, unlike in robbery. The second is light threats. This is a threat to commit a wrong not constituting a crime, but there is a demand for conditions. So the wrong threatened does not amount to a crime, but is always accompanied by a condition. This is similar to blackmailing. And the third is other light threats. This is where the wrong does not amount to a crime and there is no demand for money. Now, class, let's distinguish threat and coercion. When we speak of threat, this is where the harm or wrong is future and it is conditional. But for coercion, the threatened harm or wrong is immediate. It is personal and direct. Okay? And for threat, this may be by intermediary or in writing. But with coercion, it cannot be through an intermediary or in writing. And for threat, it is generally committed by intimidation, which is future and conditional. But for coercion, it is generally by violence. No? Although it may be by intimidation, if serious enough, it may be direct or immediate and personal, such as by means of the use of firearms. Now we have the two kinds of coercion, the preventive and the compulsive coercion. Preventive coercion is where offender uses violence to prevent the victim from doing act not prohibited by law. So if the act prevented is prohibited by law, there is no grave coercion, but some other crime like physical injuries if it resulted to injuries, or unjust vexation if no injuries resulted. And the second kind is that of compulsive coercion. This is where offender uses violence to compel the offended to do act which may or may not be prohibited by law. So, class whether the act is prohibited or not, it is grave coercion. Okay, next class is intimidation. This is an intentional behavior that would cause a person of ordinary sensibilities to fear injury or harm. It is not necessary to prove that the behavior was so violent as to cause terror or that the victim was actually frightened. So, intimidation is in this form like that of robbery if it is immediate but condition coupled with demand for money or any condition. It is also a threat if it is for the future or conditional, and it is in a form of coercion if it is direct, immediate, and personal, or it is serious enough. Then we have unjust vexation. This is also a form of light coercion. It is a form of causing annoyance to another person. And this unjust vexation is a crime against personal security and not against property. Malicious mischief is a crime against property, while unjust vexation must not amount to dishonor of another, otherwise if it is slander by deed. So in the case of unjust vexation, there is no need to allege malice, restraint, or compulsion for unjust vexation, which exists even without the element of restraint or compulsion. It's because this in turn is broad enough to include any human conduct which would unjustly annoy or irritate an innocent person even without some physical or material harm. This is from the people of the Philippines versus Baleros. And finally, class, we have our Republic Act number 4200, or the Anti-Wire Topic Law. So this law penalizes the act of secretly overhearing, intercepting, or recording private communications by means of devices. So if done with, let's say, officer, this is absolute disqualification from public office. Or with alien, then this is subject to deportation proceedings. Okay, so that would be all, class, for this topic. And for your activity, make a case digest on at least 2 of these selected topics. You have people of the Philippines versus Guillermo, You have also People of the Philippines versus Romeo G. House. And you can also have People of the Philippines versus De La Cuesta. And Ramos versus CA with those reference number class. You can check that through the web. And once you're done with your activity, you can send that to the Google Classroom. And you are given 1 week to prepare for your output. So again, class, thank you for watching. See you in our next video.